My name is Thilo Maran. I'm Professor of Public Law and International Law at Ludwigs University. May I welcome you warmly to our first ABM Bar Menachem talk. Yesterday was International Holocaust Remembrance Day. 27th of January is an International Memorial Day that commemorates the victims of the Holocaust between 1941 and 1945. As we all know, however, anti-Semitism is not just something that occurred in history. Unfortunately, we are confronted with it today. It is a present-day challenge. Today's anti-Semitism has many causes and takes many different forms, and it is a challenge for a civil rights-based democracy to properly address this. The International Holocaust Remembrance Alliance in 2016 has adopted the following working definition for anti-Semitism, and I quote, "Anti-Semitism is a certain perception of Jews which may be expressed as hatred towards Jews. Rhetorical and physical manifestations of anti-Semitism are directed toward Jewish or non-Jewish individuals and or their property, toward Jewish community institutions and religious facilities," unquote. This working definition has found its way into numerous national institutions, with Germany endorsing it in 2017. Recently, the European Union has published a handbook on the working definition of anti-Semitism prepared by the Federal Association of Departments for Research and Information on Anti-Semitism, or as we use the acronym RIAS. This new project will focus on courts in particular, which we are going to pursue with funding from the German Research Association, Deutsche Forschungsgemeinschaft, and we are just about to start another project that is going to start in August with funding from the Federal Ministry for Education and Research. This new additional project is a network-based project which is coordinating research that is conducted by Humboldt University Berlin, the Moses Mendelssohn Center at the University of Potsdam, University of Heidelberg, and us in Gießen coordinating the research. We have RIAS on board as well. Our project will address the problem that the judiciary has so far had great problems with handling anti-Semitism. The judiciary, however, is essential for the effective fight against anti-Semitism. Unfortunately, there have been very few scientific analysis, and it is a pleasure to have one of the very, very, very few authors who have properly researched this with us today as our guest speaker, Dr. Sergey Lagodinsky. I will say a few words later, and Ruth will introduce you. Our project, our new project, this one funded by the German Research Association and the one that we are going to start in August, actually addresses this problem, this lack of expertise which we see, including the most important legal areas. We aim to take stock of the current situation, in particular to provide answers to the question of the legal concept of anti-Semitism, but Ruth will later introduce our project, which is funded by the DFG, in a minute. We, and this means Dr. Ruth Paas and me, with a team of young researchers, many of them are already present today, and colleagues have acquired funds from the German Research Association to also do comparative research in this respect. We will look at the situation in Poland, in France, in the United Kingdom, and in Germany, and we hope that we will actually manage to get some results out of this. Our overall objective in the long run is that we will manage to provide material for the judiciary, that they can better apply the notion of anti-Semitism. We also hope that police and other branches of the executive will be able to do so. And we will provide some training programs, which we hope that will actually transfer this into practice. Now, today we start with our series of Abraham Bar Menachem talks. Our series of talks is named after him, who was born 1912 in Gießen-Wieseck and who died in Netanya, Israel in 2017. He studied law and completed his doctoral thesis in 1933 at the then Ludwigs University, Gießen. The rise of National Socialism prevented him from taking the bar exam, and in 1938, Bar Menachem and his wife escaped to Palestine, where he worked as a lawyer and later was elected mayor of the Israeli city of Netanya. Throughout his life, Bar Menachem, who is an honorary citizen of the city of Gießen, and I very much welcome the mayor of the city of Gießen, Ms. Grabe-Bolz, to our talk. He tirelessly contributed to the reconciliation between the Jewish people and Germany. It is a great honor to name our series of talks in his memory with his family's kind permission. I now particularly welcome the president of our university, Professor Mukherjee. I've already mentioned the mayor of our city, Mrs. Grabe-Bolz. We have representative of courts with us, and above all, today's speaker, member of the European Parliament, Dr. Sergey Lagodinsky, who is vice chair of the Legal Affairs Committee, and Dr. Doris Liebscher, who is head of the Ombuds office for the Berlin State Anti-Discrimination Act. She will actually comment the presentation by Sergey. May I finally express my gratitude to the Deutsche Forschungsgemeinschaft, to Justus Liebig University, to my team, and to everybody else supporting our efforts. I pass on to President Mukherjee. Thank you very much.
Yeah, thank you very much, Thilo, for having me here at this inaugural event, at the kickoff event for the first Abraham Bar Menachem talk. Thank you also to Ruth Paz and all the other organizers. It's an honor and a privilege to have this inaugural event under the auspices of Justus Liebig University Gießen. Thilo, you already hinted at the link that we have to Abraham Bar Menachem, a real pioneer of reconciliation between the Jewish people and Germany, and especially between the city of Gießen and our partners and friends in various locations, but particularly in Netanya in Israel. It is a pleasure to have Dr. Lagodinsky here as our first speaker in this new lecture series. And I would like to welcome all the other special guests that Thilo already mentioned. In addition to the Lord Mayor, Dietrich Grabe-Bolz and others, I also saw in passing, by the way, Professor Zechlin, a colleague of ours and a member of the supervisory board of the Board of Trustees of the University of Gießen. So a hello also here to Professor Lothar Zechlin. It is a pity, of course, that we can't come together in physical presence to a normal lecture performance in Gießen, but the difficult pandemic situation is that it is. But it also shows nicely, as I feel, that it does not stop members of JLU and our colleagues worldwide to come together in digital formats and to address important and interesting topics via these digital formats, like this Zoom meeting now. Abraham Bar Menachem is an alumnus of JLU, and he was supported in spite of the rise of National Socialism in the 1930s by his supervisor, Professor Dr. Wolfgang Mittermeier, one of the few colleagues, then colleagues at Justus Liebig University, whom we really see as people that resisted the temptations and the atrocities of the National Socialists. He supported him in receiving his doctoral degree despite the rise of the National Socialist dictatorship. It so happens that Dr. Bar Menachem actually, in honoring Professor Mittermeier, his supervisor, advocated a prize in memory of Professor Mittermeier. It is a prize that is donated every year by the Erwin Stein Foundation ever since 1996. And Dr. Bar Menachem was present as guest of honor in 1996 here in Gießen when the first Wolfgang Mittermeier Prize was awarded for excellent achievements in study in the study program in Gießen. There is a long tradition of projects at JLU in connection with anti-Semitism. You are the experts, you are well acquainted with this tradition and this history. And there is this new DFG funded project, Seeing Anti-Semitism Through Law, that is now the most recent addition to this tradition of projects funded by the DFG and others. I would like to pinpoint one structure, one research site that we have at the University of Gießen, because it is also a unique selling point, if you so wish, of our university and its profile. It's the research site for Holocaust literature. It is the Arbeitsstelle Holocaust Literature, a research site that is unprecedented and finds no second example anywhere at the German university, an interdisciplinary institution coordinated by Professor Sascha Feuchert that examines Holocaust and concentration camp literature, adopting a literary as well as a didactic perspective. And the main focus is on collection of texts of those who survived the Holocaust in order to make them available for future generations once eyewitnesses cease to exist. And I mentioned this also in the light of yesterday, a day of particular significance in Germany, because we see, of course, that the last eyewitnesses will soon no longer be available to us. So such institutions, also the new DFG funded project, are very important in the light of the phase in which we are historically, with the fading out of eyewitnesses in the years to come. So let me say a very warm welcome once again to all of you. I'm very happy that you meet in the digital reality. And I'm looking forward to the talk and the discussion afterwards. And I hope that you all stay healthy, regardless of where you are on the globe. A warm welcome to Gießen, to virtual Gießen, if you so wish. Thank you very much.
Thank you very much, Mr. President, and thank you very much for coming and joining us today. It's important that you mentioned Professor Feuchert. He's a part of our DFG project as well, and he's also taking part in the board of our project, as well as Sergey and Doris Liebscher. So both of them are escorting us throughout the project. In any case, so apart from today, you're in for it. You're in for the whole ride. So as you can see, I'm super excited to be here today, even if here, as everybody has already mentioned, is more virtual than I'd ever imagined or expected a year ago. When we literally a year ago sent in the DFG application for this project. Indeed a long year, but one of my New Year's resolution was not to talk so much about it because it's just boring. So let's put it aside and stick to 2021 because it's exciting, and we have these two amazing projects that are super important that deal with law and anti-Semitism, both on a national level and an international level. And today is Tu B'Shvat, so this is the Israeli, or sorry, not Israeli, but the Jewish holiday for the New Year's of the trees, which for me personally has always been the first day of the end of the winter. Now, regardless of where you live, yeah, but it's coming. So the spring is coming, and I think we should keep that light in mind because there's no way around, changing the weather. But speaking of light, it's a high time for me to literally, for maybe the first time in public, thank Professor Thilo Moraun for all the years of cooperation that we've been through, and for the forthcoming years that I expect to be just as productive and just as much fun as we've experienced thus far. So thank you so much to Timo and the rest of the team in Gießen that you've literally made Gießen, of all places, another academic home for me, which is just nothing short of fantastic. So thanks so much for that. Yeah, so before moving to introduce a little bit more our speakers of our first speakers of the ABM Talkers, not speakers, but talkers, today I just want to briefly mention a couple of things about the DFG project. So as I see it, we have a twofold project ahead of us. And one, the first part of it will be the creation of a straightforward empirical comparative data bank of court processes and instances that involve anti-Semitic hate offenses. As Thilo has already mentioned, we will unpack 4 different countries as examples, and those are UK, France, Germany, and Poland. And we just want to look closely at if and how different courts, and here we have administrative, constitutional, criminal, and private courts, and how they deal with any sort of anti-Semitic cases that come or do not come before its gates. The second aspect of this project is the need to contextualize some of these instances socially. So as we all know, both anti-Semitism and law are integrated and interlaced aspects of society. So how we conceive law, justice, but also anti-Semitism is socially construed by many fantasies and anxieties. Here I just want to take an example from yesterday, because I did also move in and out of different Zooming sessions dedicated to the International Holocaust Day. And it struck me how many times the words remembrance, justice, and even the IRA definition, so the non-legally binding working definition of anti-Semitism that Thilo has mentioned also, it came up so many times. In fact, the official event by the Israeli government that Avi has been a part of organizing is even been called Remembering, Perpetuating, and Pursuing Justice. So all of these things obviously have so much to do with the legal form, and yet we need to think, what does the legal form promise us here when it comes to anti-Semitism? And what do these words imply about legal limitations? And these are literally the kind of, a priori questions that we begin these projects with. We invite, so the idea for the ABM talks is to invite different people, different professionals, to discuss aspects that relate to these issues from different spheres of society. So we're not only looking for people who are experts in law. We would invite politicians and artists and anybody who has a keen interest or has any experience in this matter that is relevant is welcome to join us, either as passive listeners or active participants and talkers. So please feel free to contact us as well if you guys are interested. I am very pleased to introduce our talkers, who are actually the embodiment, if you will, of people who have both experience in practice and in theory with these issues. So I don't need to add so much to Thilo's presentation of Sergey, but only I would be a Polish Jew enough to mention that he has a law degree from the University of Göttingen and an MA in public administration from Harvard. He got his PhD from the Humboldt University that is dedicated to anti-Semitism and law. In fact, his book that Thilo has also already mentioned is entitled Kontexte des Antisemitismus, rechtliche und gesellschaftliche Aspekte der Meinungsfreiheit und ihre Schranken. He then, before becoming a member of the European Parliament, where he's today a vice chair of Legal Affairs Committee, he worked as a program director of the AJC and headed the EU North American department of the Heinrich Boll Stiftung. Doris Liebscher equally has gotten her PhD at the Humboldt University. In fact, that's something that we're all kind of share. We all met in that environment. Before she studied, while studying in law in Leipzig, she also established the Saxony Anti-Discrimination Office Advice Center, which is an NGO intended to help also by giving legal services in order to face discrimination in all walks of life, and she's still a part of that initiative, but has, after finishing her PhD that is currently being published, Dr. Liebscher has recently become the head of the new Ombuds office for Berlin for Anti-Discrimination Act. So with this, I will take a breath and I will give the floor to Sergey, who will enlighten us on all of these issues with a topic that includes, so the title is as Anti-Semitism and Legal Rules, the Complicated Story of History and Identity, which is nothing short of being the most fitting title for our kickoff event today.
Thanks so much. Thank you, Professor Maraun. Thank you, Reut, and of course thanks to the President for his introduction. It's a huge honor to be here. This is a project that I think we all have been missing for many years, if not decades, in Germany. I also think that this is a project of emancipation and reclaiming the topic. And maybe I will mention a little bit later why I think that this is important also to see in this context. In the title that Reut mentioned, I talk about the three components: law, history, and identity. And I don't want to talk too long. I know the Zoom context is sometimes a little bit exhausting, so I would stick hopefully to my 20 minutes, and you can stop me, Reut, if I speak too long. And then I'm looking forward to Doris, who would then comment or present her own perspectives. But I wanted to start, as they say in German, first the duty, then the fun. So let's start with law and then go to history and identity. A German author of she was in the Berliner Zeitung at that point in 2004, wrote about the NGO forum and the OSCE conference on anti-Semitism, the first OSCE conference on anti-Semitism, which took place in Berlin. And I organized the NGO forum at that point. And this is, by the way, where the definition, the first draft of definition, also appeared, that also Professor mentioned in his speech. But he wrote about that event, and one of the sentences was especially interesting to me. And he wrote, "Anti-Semitism is legally banned in Germany," and that's an interesting point. This was an interesting perspective. Well, first of all, this is a legally wrong perspective. But second, this is a perspective that tells us something about this. The attitude, the view, and the discrepancy between legal reality on the one hand and the legal desire, or the moral desire of this society on the other hand. And this is something that I think is important to keep in mind when we talk about the issue of anti-Semitism and law. We focus most of the time on the desire to prohibit anti-Semitism. And this is a perfectly understandable impulse that we all share, but it is an impulse which is difficult, and I would say, dare to say, also normatively not desirable to implement. Why? Because prohibition of anti-Semitism as a goal in itself does not exist in a vacuum, and we must recognize that we live in a democratic context and we live in a very complex context. Something that makes it very difficult to legally tackle the problem completely. First of all, and I don't have to explain it here, but I assume that there are people of different disciplines here, because this is an interdisciplinary point. On the technical side, it is very difficult for a very clear reason, because on the one hand, we have a strong protection of freedom of speech with Article 5 and with the guarantee that on the general laws, allgemeine Gesetze, can prohibit any opinion. And on the other hand, the difficulty is also because it is effectively impossible to prohibit anti-Semitism, because we have two trends that I think we should keep in mind. One is there is a variety of anti-Semitisms. There is not one anti-Semitism. And this variety is extremely, extremely broad. So even the statement anti-Semitism is prohibited is just objectively not possible. Number two, even these variety has a kind of, as I would call it, a self-modernizing dynamics. Anti-Semitism, as we know it, we know the historical topoi, we know the historical pictures, have always been able to self-modernize, to update, as we would say today, itself and adjust to the new realities. Just to bring a very easy and common example, the theories that we have today about COVID are all repeating and updating the old anti-Semitic stereotypes. Some of them assume that there is something Jewish about the conspiracy, and others just take the same structure. So it makes it very difficult to tackle anti-Semitism. I usually talk about the core of anti-Semitism, which is easy to find. Of course, there's very clear anti-Semitic statements, and then there is a periphery of this term, periphery where it gets ambivalent. There are statements, and anyone who knows the theory of freedom of speech in Germany knows that the Constitutional Court, or any court, the first thing they would do is to figure out whether a statement, a saying, has two meanings, more than one clear meaning. And if there is a meaning which is not legally punishable, then in theory, this meaning should be taken in order to assess whether this is legally acceptable or not. But I think with anti-Semitism, and I don't even need to refer to the Soldaten sind Mörder-Urteil, the ruling of the Constitutional Court, where it is actually worked out in a very nice way. We have a problem with anything which could be understood as a social critique on social situations. And this is something that I think we have underestimated for a very long time. We have talked about this variety of anti-Semitisms, but we don't have a cluster for we talk about even some even say Muslim anti-Semitism, which I don't like as a term, but there is a classical, there is a Christian anti-Semitism, there is a racist anti-Semitism. So I think what the most problematic thing from the legal perspective is anti-Semitism as a social critique, because what we have in terms of anti-Semitism in a way of conspirological aspects of it is can very easily be framed as critique on capitalism, critique on the bank system, critique on the finance system, and we know all those topics. And actually, there are scientists on anti-Semitism who have spelled it out. Moshe Postone has a very interesting theory about how the criticism of capitalism has been divided in two parts, where the criticism of something productive, like the production means, is less ambivalent and less anti-Semitic than the critique of the financial side of capitalism. This is where a lot of anti-Semitic topics get into play. And any financial criticism, and you can see this on, for example, criticism of Rothschilds, right? Where not a word of Jew is being used, but a picture of Rothschilds is being used, where you know what it is, but it is very difficult legally to tackle. This brings me to a couple of assumptions in the legal realm, and then I will go to identity and history very briefly. I think it is important to first of all stop being obsessed with bans and prohibitions and focus instead, and this is, by the way, something that I tell to my Jewish friends and Jewish colleagues also, because there is, of course, this longing for security and safety. And this is, of course, something that absolutely understandable, also for non-Jewish people who don't want to hear this in this country. But it is a very difficult task. And I think it is much better to accept that we are here in a democratic discourse, and we have to be careful with what we want to ban. So instead, and I think this is a project which is especially interesting on that, strengthen awareness of law enforcement and judges in applying the laws that we have, in applying and strengthening the concept, not of, I would say something maybe people wouldn't agree with this, and I don't mean it in the kind of the holistically, but not so much focusing on the concept of hate speech, but much more focusing on the concept of hate crimes, where something which is already punishable by law can be punished with more gravity. 46 of StGB, yeah, with more gravity, if it is done with an additional layer of anti-Semitic motivation. That's why I think that the discussion of adding anti-Semitism to paragraph 46 of the Criminal Code of Germany was a very good debate, because it did not go into kind of creating an anti-Semitism as a new crime, but making it graver any crimes that we have. I think we need to continue to stick to the dichotomy of libel, incitement, Beleidigung und Volksverhetzung, because this is something which also secures the free space in our society beyond, of course, anti-Semitism and racism, etc., etc. So this, I think, is important. And in that context, I would like to address the issue of IRA, of this definition, which is being heavily and hotly debated in Germany. I think that the debate is going in a very wrong direction from both sides. On the one hand, we have a lot of push for this definition to be misunderstood and misinterpreted as the final say in societal and also legal discussions, and this is not. And as I said, I was drafting or co-drafting, assisting to draft this definition at the beginning. It was very important for us. This was a push from the American organizations where the freedom of speech is very important. So if you look at this definition, you will see how many safeguards and ambivalences is built in order to show that this is a guiding principle that shows by way of example where, I would say it's a Bauchgefühl definition. Yeah, it helps, and it should help to law enforcement and to judges and to courts to get this Bauchgefühl that they don't have now. And coming to the Rothschild case, you might know, I think, Doris, we talked about this, or we wrote about this in the text, the ruling of AG Prenzlau, the magistrate court of Prenzlau, a little city in eastern Germany, where they had to decide whether an Alternative for Germany activist, local activist, said something anti-Semitic by putting the picture of what's the name of the Simpsons figure? This greedy guy. I'm not a Simpson expert. So putting this picture near the picture of Rothschild, the bank Rothschild, and putting down there under the picture saying, our family rules the world. And this was the question of whether it is anti-Semitic. I would agree with the court who acquitted the guy and said that this is too ambivalent to say that this is incitement. But the interesting thing is, how did the court arrive to that conclusion? And the court arrived to that conclusion by quoting Wikipedia texts on both anti-Semitism and Simpsons in order to prove that this could not be deemed anti-Semitic. And this is, in German, you would say Armutszeugnis for our courts and judges. And this should not happen. And therefore, Doris and colleagues and your project is so important. We need people to know what they're talking about and not Google Wikipedia to figure out what is anti-Semitic and not. So this is number one. Number two, the point that is important to me is also we need to strengthen public discourse about what is anti-Semitic and not stifle the discourse, strengthen the discourse. We should, for example, go away from this very, I think, German and legalistic way of saying that everything that is anti-Semitism should be prohibited on the one hand, but then drawing from that, saying the conclusion, everything that is not prohibited is not anti-Semitism. This is a totally wrong conclusion to draw. Of course, there are things that are not prohibited, that are not banned, where we will not get a ruling of the court, but we still should and can be able to tell and to call their names and to say that this is anti-Semitism. And there I come to the final point in this part, and I know the 20 minutes is probably over, but still, we have a problem on the other side, that we are criminalizing accusations of anti-Semitism. And this is, I think, something which destroys the public discourse, open and honest public discourse about what is anti-Semitism and not. And I'm not a big fan of people like Henrik Broder, with whom we have regular fights. And I'm not a huge fan of many others. But the fact that they were well, it's not sentenced. This was a civil law. So they were obliged to abstain from calling people like Elsässer anti-Semites. This is a disgrace. We are saying, and we are giving a signal to our public debate. You are not allowed, and you should not be able to pronounce your own assessment of somebody saying in an honest and open way, because you should be afraid of them dragging you to the courts and saying you are not allowed to assess and to evaluate what they're saying. So I think we need to go in both ways and say, of course, not everything anti-Semitic should be illegal, but not everyone calling someone anti-Semite without having used Wikipedia or whatever to make sure that this is right should also be banned. So, and the last one, and I think this is important, educate and confront. Don't overlook new forms of anti-Semitism. And this is why this project is so important. I am afraid that I'm already over my time, and Riud, you have to tell me, and that the fun part about identity and history will probably be something for our next discussion. Riud, you have to unmute yourself if you want to talk. Riud, you're muted.
Okay. Thank you. You have 5 more minutes if you need them. So because
maybe
you have 20 minutes, you had 25 minutes. I mean, you can also just give them up.
Yeah, maybe just very briefly, because I think this is very important for this project from my point of view. I think that why I meant that this project is kind of a reclaiming of this discussion, and I will focus only on one thing. I think that, speaking of identity, dealing legal dealings or legal thoughts and discussions in Germany in courts after the World War II, after the Holocaust, were always dominated, from my perspective, by the idea of what kind of identity this country and this legal system wants to be. And this is something which is applaudable, and this is something that is very, those courts have earned, from my perspective, a lot of respect. Why? Because I think, and this is something I put also in my book and my research, courts in Germany have become also a place of mourning, place of memory, lieu de mémoire, where if you read many of those judgments and rulings, you would see how the courts, especially in the after-war time or in the 70s, it hurt. It was a very difficult way of how to reconcile freedoms on the one hand in this promise that something like this should not happen again on the other hand. So this was a work, like a mourning work by courts. But on the other hand, and this is the downside of it, the identity that was strengthened, constructed, and promoted through this was a, I would say, white German non-Jewish identity. And there was very little place and very little possibility, just because the Jews were not there, for actual Jewish perspectives on this issue. And therefore, something happened that I called objectivization, for example, or a construction of a Jewish identity and construction of a Jewish dignity by German courts, which became a very vulnerable Jewish dignity. Look at the, for example, the libel, Beleidigung unter Kollektivbezeichnung, how it was dealt for a very long time, where generally religious communities could not be insulted. Yeah, if I say, you know, I'm sorry to say this, but if I say, you know, something negative about Muslims, they could not complain and say that the single Muslim was insulted by that. But if you said something about Jews, then the court said, this is a Sonderfall, this is a special case because of the whole situation, and anything you say something negative about Jews, every Jew feels insulted by that because it's in Germany. So there was, nobody asked Jews, but there was this kind of construction of what Jews would feel and how they would be insulted. That had also something to do for a very long time with the fact that the Holocaust denial was not, of course, regulated as 133 now, 130 paragraph 3 now, but it had to go through libel, and it had to insult someone in order to be banned. So in dealing with Germany's own demons, in trying to get them under control, German legal system needed to construct Jewish sensitivities. And I think that now we moved on, and actually the speeches yesterday and the Marina Weisband speech and many others, I think we are now in the moment which I call a new emancipation of Jews in Germany, where Jews have stopped being objects and have claimed and reclaimed their own perspectives, and they want to shape this society. And I think that's why this project, where everyone works together with all these varieties on perspectives on this issue, and also personal perspectives on these issues, and not only Jewish, but also Jewish. This is, I think, a huge asset, and a big asset, not just for the University of Gießen, whom I congratulate on that, but also generally for Germany, and also maybe beyond that, definitely for Europe, because I don't know that many similar projects on the European scale. So I'm looking forward to working with you or contributing as much as I can, and also to the results of this project.
Thank you so much, Sergey, for this. I often, I mean, yeah, as the title of the whole project speaks of promises, like legal promises. So what can the law or the legal form promises, and what are its limitations? And I totally agree with you with the need to balance, so the tendency to get the prohibition on the road, like let's just prohibit as much as possible. This is exactly the difficulty that I often feel. That in Germany, there is a congratulatory moment for the IRA definition, just because it kind of opens up the possibility of even using some kind of a legal measurement for anything that came after 1945. Because up until 1945, you know, it's all dealt with. And 1945, there was no anti-Semitism anymore in Germany. And then the IRA definition is kind of giving us a possibility to deal with that, but we should really resist it, right? And that's, as you say, was also the intention of your attempt and your participation with the creation of the definition, together with Ken Stern and others, right? By the HSC. But anyway, I don't want to take more space. Doris, the floor is yours. Thank you so much, Sergey, for this. Yeah, I'm so happy to have you here, Doris, as well. Doris was also so kind to join me the other day with my students and give her take on anti-discrimination law. So that's, yeah, the floor is yours. You need to, yeah, okay.
Okay, hi. Thank you, Reut, for introducing me so warmly. And yeah, it's a pleasure for me. I'm super excited to be part of this conversation and of the project Reut and Thilo Maraun yeah, already mentioned and explained here. And I'm very delighted to comment on you, Sergey, and finally meet you in person. You mentioned that we wrote an article together and we never met because of Corona. So this is the first try to get closer. I can pick up on many aspects you mentioned, Sergey, regarding the problems to address anti-Semitism in German legal contexts accordingly. And you spoke in the beginning of the tendency or the desire to prohibit anti-Semitism, which is done usually by criminal law. And I will have I think I will take 5 or 6 minutes to speak to you. I will have a short look into a legal area that tries a little bit another path than criminal punishment or prohibition. And this is a field I have worked in for many years. Reut has mentioned it. This is anti-discrimination law. And anti-discrimination law differs from criminal law in many aspects. It aims not so much to punish, but to redress and to compensate discrimination, and it does so below the level of actions of violence. Yeah, so you don't have to show that there's intentional hate in it. So this means usually everyday situations such as applying for a job, harassment or disadvantages at the workplace, at school, at university, discrimination experienced when looking for a house or apartment to rent or to buy, when join a gym or other social facilities, when trying to enter a bar, a restaurant, or a club, which is not possible right now, but it hopefully will be soon. So this kind of everyday discrimination cases, they are tackled by anti-discrimination law. And of course, last but not least, discrimination by state officials, be it the police, be it the job center or the local school board. And the legal proceedings in these anti-discrimination cases are not held in criminal courts, but either in civil courts or in administrative courts. And the challenge in these cases is not so much to prove an anti-Semitic intent of the perpetrator. Yeah, Sergey, you has explained the difficulties in the different cases. Yeah, when it comes to define anti-Semitism and to prove an anti-Semitic intent. In the anti-discrimination cases, the difficulty is more to prove at all that discrimination took place, because the defendants often deny this, or they downplay discrimination, or yeah, they're doing so as showing it as oversensibility or misunderstandings. And anti-discrimination commissions, be it at universities or or courts, they tend to follow this downplay of the experiences of discrimination. This is one part of the problem I see in anti-discrimination law. But I want to talk on another part, and this leads us to the question of identity. Anti-discrimination law prohibits discriminations on grounds. Yeah, these are called anti-discrimination grounds, categories, be it gender, be it race, be it belief, be it ethnicity. And Article 3, paragraph 3 of the German Constitution, the Grundgesetz, which is the anti-discrimination provision in our constitutional law, for example, prohibits discrimination on the grounds of race and belief, where Section 1, Allgemeines Gleichbehandlungsgesetz, the German Equal Treatment Act, which is a civil law, prohibits discriminations on the grounds of racial or ethnic origins and religion. And as you all know, and I think, Sergey, you have already mentioned it, the question, what are Jews? Are Jews a religion, a nation, ethnicity, a culture, a community of faith, is highly disputed within the Jewish population. And I'm quite skeptical if German courts should discuss the topic. You mentioned that, I don't know if it's sometimes or often, the research projects of Reut and Thilo will show the results that sometimes or often judges use Wikipedia as a definition for anti-Semitism. And my research, I have researched how German courts define race in the Article 3 of the German constitutions. I have found many cases where they don't use Wikipedia, they just use their Brockhaus edition, which they have in the bookshelf. And if we are lucky, this edition is edited after 2000, because after 2000, we can find definitions of race as a social constructions, but before 2000, we can find biological definitions of Menschenrassen. So it is really, it is a complicated and dangerous path to send German lawyers to define if Jews are a race or not. The next problem is that the legal question, what Jews are, is absolutely incoherently answered within the international and the supranational legal framework. Yeah, so we deal with either the definition in the International Convention for the elimination of all kinds of racism. Then we have European law against racism, and then we have German law. And so whereas Jews under the German constitution are a race, whether in a biological way or hopefully in a social constructive way, they are in the scope of the European legal anti-discrimination framework an ethnicity. And sometimes they are just a religion. So we see how difficult it is to put the experience of anti-Semitic discrimination into this separate categories. Didi Herman, she's a British legal scholar, has written an excellent book about this topic, which is called Jews, Jewishness, and English Law, which I can highly recommend. And I hope that this kind of book will be written soon for the German context. Okay, I will come to another problem of this category-based law, which brings me again back to Sergey, to you talk. This categorizing of the experience, of the complex experience of anti-Semitic discriminations has difficulties to grasp the modernized forms of anti-Semitism. You mentioned different forms who leave the old racial argumentation and are more tied to a critique of capitalism or a critique of Israel. And there is a quite well-known case where we have all seen how difficult it is for German courts in the anti-discrimination area to grasp these new forms of anti-Semitism. And this was the controversial ruling of the Frankfurt Regional Court on the flight ban for Israeli citizens from Kuwait Airways. The court had decided that for the Kuwaiti law on which the airline based its refusal, it does, and I quote, not matter whether the Israeli citizens are of Jewish, Christian, or other faith or ethnicity. So they denied the claim, saying that this is the experience of this Israeli citizens does not fit in any category of the Anti-Discrimination Act. What happened is that the higher regional court of Frankfurt finally overruled this decision, deciding that it was an indirect discrimination on the ground of ethnicity. And what we see then is that there has been a legal debate on how to make sure that legal protection against anti-Semitic discrimination is granted to different forms of anti-Semitism. And I want to end my short remark with proposing two different paths. One proposal is to amend anti-discrimination law and to add the ground of citizenship, and therefore grasp forms of, I call it anti-Israeli anti-Semitism. I don't know what the right English term is. But there's another part, and this part has been taken by the legislator in Berlin. Section 2 of the Berlin State Anti-Discrimination Law, and this is the law I work with as an ombudswoman now. This section reads, this act prohibits discriminations on the ground of ethnicity, religion, racist attributions, and anti-Semitic attributions. And I have to say that I'm quite happy with this wording because it focuses not so much on the questions, what are Jews, but on what anti-Semitic perceptions are attributed to them. Yeah, I think I leave it here, and I'm looking forward to discussion, and I thank you for your attention.
Thank you so much, Doris, for this. Yeah, it opens up other multifaceted venues and by questioning things, but also by suggesting different directions. I open the floor now for questions.